morning's docket. I call case number 106096, State of Kansas v. Keel.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing this morning on behalf of Danny Keel. I request 3 minutes for rebuttal.
3 minutes is granted. Mr. Hodgkinson, because we have a larger audience today, would you mind taking some care in presenting some of the facts of this case instead of diving right into the legal issues?
Sure, Your Honor. This is a possession drug case out of McPherson County. Have to be careful. And involves the search of a residence in McPherson County, where police officers went into the residence, and as the parties agreed that they found evidence of drugs and some things that they alleged were paraphernalia in the house. And they also found my client, Mr. Keel, who was found hiding, sort of, in a secluded part of the house. And the issue in this case, it went to a jury trial, and Mr. Keel was convicted after a jury trial, and he was sentenced to, I think, 34 months in prison, but I have to double check that. So those are sort of the basic kind of case this is.
Thank you.
There were two people in the house. The
That's right.
defendant and his girlfriend, which will come into play as to who's...
Yeah. And at trial,
Yeah.
the girlfriend came in and testified that the drugs and the paraphernalia were hers. But the jury apparently still deemed it appropriate to convict. So there were two trial issues in this case, Your Honor. The first one was sufficiency, and I wasn't planning to go over that. I know the court knows the standard on sufficiency well, and the respective position of the parties is set forth in the briefs. So I was planning on moving to the instructional issue in this case, which has to do with the instructions given for possession of drug paraphernalia. What our visitors might know or not know is that anything can be drug paraphernalia. Any number of otherwise innocent items can be drug paraphernalia.
And isn't there an instruction that deals with that question? I mean, you're right. Matches could be paraphernalia. A spoon could be paraphernalia.
A cup.
But it has to be associated with the ingestion or the taking of the drug. And isn't there an instruction that directs the jury to that?
That's right, and it was given in this case, Your Honor. Instruction number 3, drug paraphernalia means all equipment, products, materials of any kind which are used or intended for use in ingesting, inhaling, or otherwise introducing into the human body a controlled substance.
Right.
That's the definition of that, and we have no objection to that. That's exactly the kind of instructions to be given. Our concern is what immediately follows in that very instruction. Drug paraphernalia shall include, but is not limited to, pipes, bongs, the things that the state put on evidence of in this case. And so our claim in this case, and the second case actually too, is that additional aspect of this instruction is improper because it essentially, this is what the Court of Appeals, and I'm reading from their decision at page 8, unlike the instruction in Bryce, the instruction here did not literally and expressly state that the objects found in Keel's residence were drug paraphernalia. Does not literally and expressly state that. The instruction says drug paraphernalia shall include, but is not limited to, pipes, bongs, things that they allege they found in this house. So I guess that's where I think the disconnect is between our argument and the Court of Appeals finding in this case. That's exactly what this instruction does. I was sort of racking my brain this morning thinking about examples of this kind of thing. And the only one I can think of, and I bet you can think of better ones, but is like with income tax law. Sometimes that you'll have tax provisions that will describe what is income, and there are these general sort of broad definitions of it. And as lawyers, we might be able to say, well, I don't know, maybe I could argue that there's one thing, but then we'll have a provision that says this is income. Stop thinking about it. We specifically are saying this is income. We've made that determination. And that, to me, is what this instruction seems to do. It's not its intent. I think the Court of Appeals is right when they say the intent of this was to inform the jury which objects the state claimed to be drug paraphernalia. That's I think the intent of this pattern instruction. But its effect is to tell the jury drug paraphernalia shall include these things. So if I'm the juror and I'm looking at something and I'm thinking, well, is this drug paraphernalia? I don't know. I mean, I don't know. I have to do my job as a juror to decide beyond a reasonable doubt, is this thing, whatever it is, drug paraphernalia? Well, here's this definition, but the judge's instruction tells me it is paraphernalia. And that to me does seem exactly like Bryce error. And that's the substance of our argument in that regard. The only other aspect of this is whether or not it was harmless error. The Court of Appeals applied a clear error test here, although I think this is constitutional error at least, federal constitutional error, as you found in Bryce, that this kind of instruction violates the Fifth and Sixth Amendments right to jury trial. And the only point I wanted to make on it was that the Court of Appeals makes an apt, and my colleague makes an apt point that the girlfriend in this case testified. She used it as paraphernalia, so that's pretty strong evidence. But again, it's not what she used it for. It would be what my client did. My client have any intent to use that? That is to say that just because somebody uses it as paraphernalia does not mean something is paraphernalia for the whole world.
And again, Mr. Hodgson, you don't take each instruction in a vacuum as itself. There were two other instructions given in this packet that deal with paraphernalia that both of them, seems to me, would not really specify that pipes or bongs are always paraphernalia, but you have to take it in the context in which they're found. That the defendant intentionally possessed drug paraphernalia to use, ingest, inhale, or otherwise introduce into the human body. And the proximity of the object in time and space to the controlled substance. So the jury was utilizing all these instructions to determine whether it was paraphernalia, not just that one specific directed instruction. Would you agree?
No, because we have no way of knowing that. A jury, and when we put ourselves in the reasonable juror's position here, reading this instruction, I think it's sort of like the example I gave, that I'd say, wow, I wonder if this is going to be a difficult problem. Oh, it's not, because the instruction tells me that these things are drug paraphernalia. So if I'm going to, as I've sworn to do, follow the judge's instructions, I would say, well, I guess that's not really a question in this case. Maybe it must be a question in some other cases, but it's not here. And for that reason, Your Honor,
Mr. Hodgkinson,
yes, yeah.
On the instruction you're complaining of, obviously it would fix it to leave off the last part. Obviously it would fix it to leave off the last part.
Yes.
Could that last part be changed in any way to make it acceptable, and what would that look like?
Absolutely. I think they could serve this purpose if they said the state alleges that pipes and bongs are drug paraphernalia, and you can't consider anything else with regard to drug paraphernalia. I mean, I would be in favor of that, right? I don't want the jury considering all sorts of things, only the things that the state charged. So I think that's the easy fix, Justice Breyer, is just to say the state charged these things. Now, as you consider whether these things are drug paraphernalia, here's the definition, and maybe here are the factors that you consider. The last issue that I wanted to talk about was the sentencing issue in this case that the court ordered supplemental briefs on. As this court, I know, is aware that since we filed and since the court granted the petition for review in this case, this court issued State v. Murdoch and educated us on some of the law, although really it was just an application of State v. Williams. And so the question in this case is whether or not State v. Murdoch applies, because several pre-1993 convictions in this case were classified as person felonies. And it is our argument that under the rationale of Murdoch, that they should not be. So I'm proceeding in this argument at the beginning here, at least, assuming that Williams and Murdoch are good law. And I know that we could reasonably disagree about that. I know that in part because we argued the other side in Williams, that a different rule should be applied. But this court unanimously in Williams said that when determining whether something is a person or non-person felony, we have to look at that crime as it existed at the time of that crime. And the problem here is, until 1993, there was no such thing as a person or non-person felony. It's entirely a construct of the Kansas sentencing guidelines. It has no meaning outside of that. And although I understand that this court in Murdoch modified its opinion to say we're only dealing with out-of-state convictions, my assumption is because this court has repeatedly said we don't issue advisory opinions. And all you had in front of you in Murdoch were out-of-state convictions. So your decision reached no farther than the case you had before. That's your typical practice. But the reasoning of Murdoch certainly must apply and I don't think can be distinguished.
There is a difference, though. The Murdoch dealt with a specific provision that talked about out-of-state, and we don't have a comparable provision for in-state.
There's no, but even that analysis, Your Honor, when you look at the provision dealing with out-of-state says you have to look at the in-state, and that was the problem, was that when you looked at what the comparable in-state conviction was, then the reasoning of Murdoch and Williams took hold. And so I would really say that the idea that it must apply and must be the case for in-state convictions is a predicate to Murdoch. If that's not the case, then you should have been able to find a comparable person or non-person offense for Murdoch and apply it. So that's why it seems like the reasoning is applicable. At the end of the day, Your Honor, if there's not a provision, if there's no provision dealing with this, then the rule of lenity applies. Then you don't have a provision. I think the legislature is working on that right now to fix that, so that in the future this won't be an issue. But for the sentencing that we're dealing with in this case, Williams, the rationale of Williams applies. And when the prior convictions in this case took place, there were no person and non-person felonies. And so we would ask that you hold that Williams applies in this case, and so the same result in Murdoch obtains.
Do you think Williams was right? And I say that because, and for the benefit of the audience, there was a case a few years ago called State versus Williams. The defender's office, which Mr. Hodgkins comes from, said that, took the opposite view of the one that the court accepted. We accepted the state's view of how it should come out in Williams. And now the defense is saying that Williams is a pretty good outcome for what they want. But let's and the state says, no, maybe Williams is bad. So let's talk about whether Williams is correct. Recognizing that you all took a different view years ago.
It's sort of a positional conflict for me, Your Honor.
Right.
So,
But having had time to
accepting
reflect on it.
I certainly understand. And by the way, the only other, before I get off of it, I haven't heard the state say they think Williams is wrong yet. I haven't heard the state say that Williams, in any case based on Williams, should be revisited yet. So I don't know that that's true. But
They moved pretty close to that in September when we had the re-argument on Murdoch.
I think there's still a bunch of clients in prison based on Williams, and I haven't heard anything. So let's put that aside for a minute. The reasoning, and this is the concern that I understood you to be addressing, agreeing with the state in Williams, that what rule are you going to use then? That the reasoning of Williams and the reasoning of the fundamental rule is we're going to apply it based on that because that's not manipulable, sort of. In fact, I thought it was interesting in the state's additional authority, the Wagner case that came down from the Court of Appeals recently, is a nice example of this because they legislate a rule. Well, how are we going to determine what, from pre-93, if it's a person or non-person? Well, we'll look and see if there was a person, is essentially what they say. They just sort of legislate that rule. And that's the problem that I think you were trying to avoid in Williams, to say, look, it's not our job to make that rule. That's the legislature's job to tell us exactly how to do this. And that your reasoning in Williams was the only way to do that is to apply this and interpret this from the time of the prior conviction. And so that's still true. And we start to see the ramifications of that now in Wagner. I mean, there are other ways you could decide, I suppose, what is a person and non-person felony. I've thought it's ridiculous for the longest time that residential burglary cases are classified as person felonies. There's no person there. If there's a person there, it's aggravated burglary. So why is it a person felony? Because the statute says so. The legislature decided it. We're done. It's a legislative determination. And I think this court wants to avoid legislative determination.
What about comparing it to the current offense, which is the other kind of route you can go to?
Yeah.
And we specifically said in Williams that was not the track. I think you can read some of the underlying cases for Williams to really say that. That's what you do. And we maybe misread that or went the other way with it. What about comparing it to the current offense?
Well, like I say, I'm here on the assumption that Williams and Murdoch are good law. Because, I mean, we did talk about other possibilities. There are other possibilities, but this court said the fundamental rule is we're going to look at the law that existed with regard to that conviction at that time.
What is the problem with what, if any, with what Justice Rosen had suggested as a possibility, doing something other than that, looking at the current offense categorization and applying that to what happened 10, 20, 30 years ago? What's the problem with that, if any?
Well, I mean, the problems would be those that you stated in Williams, that it's going to lead to potential manipulation. For example, I mean, with Williams in those kind of cases, are you going to apply it to the 1993 version for all the pre-93? Are you going to apply it to the 2000 version? Are you going to apply it to today's version? And if so, why are you choosing among those? That's effectively legislating. We're going to make a policy choice, I guess, and we're going to decide what the legislature should have done.
Hasn't the punishment for a crime always been at the date that crime was committed? And so you have a current crime that's committed on a given date, let's say July 2014. It's what is in existence at the time that crime was committed, not what was in existence 20 years ago for a prior crime, isn't it? I mean, that seems to me to be a rational way to look at this. It's what is the punishment in place at the time the crime was committed?
Your Honor.
For purposes of prior crimes, I don't.
Your Honor, we obviously thought that was a reasonable.
That's what you
that
were
was a
saying in
reasonable
Williams.
argument at one point. So I
Right.
can't escape the fact that we've even argued that at some point, but we lost. And Williams was unanimously decided in favor of the state's argument.
But the flip side of that is, if you commit a crime, you should know the consequences for your actions and whether that crime is going to be a person or non-person in the future. What consequence is it going to give you, including your criminal history? That's the flip side of, yeah, you committed this, you're sentenced now, but when you're classifying what you've done in the past, you shouldn't be surprised that you shoplifted some bubble gum and now that's considered a person felony when it wasn't at the time. I mean, that's the flip side of that.
That's right, Your Honor. There's different ways you could do this. I mean, there are. But my understanding was that this court said in Williams and followed up in Murdoch is to say that's a legislative decision to make, and there's no provision for that. So the rule of lenity sort of kicks in, and that's where we ended up.
But the rule of lenity didn't apply in Williams.
That's right.
Yeah.
Any further presentation?
No, Your Honor.
Any more questions?
Thank you.
Thank you, counsel.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I'm actually going to flip the issues unless this court tells me to do otherwise and start with the Murdoch, whether or not Murdoch applies to in-state convictions. What this court needs to do is go back to the beginning and look at legislative intent. It didn't do so in Williams and it didn't do so in Murdoch. The legislative intent requires this court to look at the purpose of what happened in 1993 when the KSGA went on, became law in the state. The
And
intent
what was the purpose of the Kansas sentencing guidelines? I thought it was to reduce prison overcrowding was one of the goals.
It was to standardize sentences for equal treatment for offenders, so there's no more disparate treatment. Uniformity, public safety, and then reserving prison space for serious offenders. And how they told everyone what offenders were serious was defining a person felony. They said these are the more serious offenses in Kansas, person felonies. It is, again, completely absurd that they said, starting in 1993, all these other serious offenses that we would have used in the indeterminate sentence don't count anymore.
Did this
They're not
concept,
persons.
I'm sorry.
Sorry.
Did this concept of person, non-person exist in either court precedent, common law, or any other source other than statutory law prior to 93? And let me follow that up. I ask that because your opposing counsel made the argument that person, non-person is purely a creation of the legislature. It's a distinction that arose purely out of statute. Do you agree with that or not?
Yes and no. I do believe that historically person offenses are more serious offenses, and they have been offenses.
But was that distinction evident prior to the statutory formalization of it?
I don't believe so, but I'm not sure.
Well, there were, these captions in the statutes that, I believe Chapter 34 crimes pre-1993 were designated as crimes against persons or something like that, and then there was crimes against property. But go on.
Justice Rosen is absolutely correct. The headings that the revisers used did designate person, non-person.
I don't know what effect that has in terms of Justice Stiegel's
Right.
question, but there were some categorization that way.
So they at least theoretically had a categorization, and then they took those same things and made them person felonies. Every single thing in Chapter 34 that was a person felony became a person felony post-1993.
But there
were
wasn't
some
a
outside. There were
I'm
some
sorry?
outside Chapter 34 that were person
Yes,
too, right?
there was. Then the list was added to because sex offenses weren't person felonies; they were just sex offenses.
And there was no distinction. A Class A, or say a Class C felony that was in the section crimes against persons was punished exactly the same as a Class C felony that was in the section that was designated crimes against property. So there wasn't any distinction in penalty by that designation.
Right, and that's the same now with severity level. All severity level 1s are punished the same way. Severity level 2. The Class A, B, C, E was more like our severity level. So what they took was they had the severity level, they reclassified it with numbers instead of letters, and then they added person versus non-person designations.
Counsel, I'm a little curious. I understood you to say that your position today is that Williams ignored the legislature's intent. Is that right?
Yes. I
Well,
think,
didn't this court adopt the state's position advocated in Williams?
and the state ignored the legislative intent too. The state got it wrong. The state, I think everyone in Williams was focused on that particular case, that outcome. Or you can say that Williams is fine and that the difference between in and out of state are the out of state has the word comparable offenses, the in state has nothing about comparable offenses. It's based on convictions. You're looking at prior convictions, and what this court has to decide is legislative intent, convictions, what are we using?
But
to score this person?
isn't the defendant correct that the comparable offense is the in-state conviction or the in-state offense?
On out of state, yes.
And once you get to the in-state offense, that's the same offense for which the defendant in this case has been convicted, which wasn't designated person or non-person.
Right.
How do you get around that? How do you square that circle?
I think it is a difficult circle to square. The only thing is that comparable offenses, if you're going to say, based on Williams, that offenses freezes it back at the time of the original crime, you can do that. There's nothing in state that says if you look at the crime. It doesn't say prior crime, it says prior convictions. It repeatedly talks about convictions, and the most sensible rule is to look at the current crime, or the new crime, as I'm going to call it, and call it new and prior crime. The new crime, and use that to figure out what's person versus non-person.
But doesn't that create the problem that Justice Johnson asked your opposing counsel on? I mean, it seems horribly unfair to have someone plead guilty, be sentenced on a particular crime, let's say plead guilty to a crime back in 1989, and here was the universe of characterizations and classifications and punishment that flows from that 1989 crime, and then have the legislature later change the rules and say that's going to be a more serious offense, and then the next time that defendant gets sentenced, that prior crime that they pled to has got a new set of rules attached to it, which makes it more, or in Ms. Williams' case, she had a whole different problem than where she was before. I mean, how do you reconcile that?
First, when you plead the collateral consequences, you never have to be aware of collateral consequences. It is absolutely, the legislator can come back and say, we're going to treat your theft. Habitual offender acts do it all the time. You have one theft, now you have three. It's going to be life sentence in California. But the flip side is true as well. What we're doing is looking at what does society think is serious now or at the time that you committed your most current offense. The flip side is also true. If harsh draconian cocaine sentences in the federal system have gone down, we wouldn't be able to fix that because we're freezing the old draconian crime. So what we're looking at is what does today's society say is a offense that jeopardizes the public safety. The legislator can absolutely make that call, and they can make that call post the person pleading guilty to their theft.
When the legislature adopted these sentencing guidelines in 1993, I don't understand, if this is so obvious and it's so absurd that we would have the rule from Murdoch, how could the legislature not cover this and tell us what to do with pre-1993 crimes?
I think they thought they had covered it.
And tell me the statute to look at that says pre-1993 crimes are covered.
One statute is the burglary statute, what you're going to talk about later in Dickey, the 216811D. It makes no sense that burglary is the only person felony post-1993. That statute came in 1993. I know that because Pfeiffer deals with it, and it said you split person versus non-person. If they didn't think everything was going to be person, they wouldn't need to explain that split. They would have just said, well, everything is going to be non-person. Why would the legislator say just burglary is going to be person felony post-1993?
Let's turn that around. Why wouldn't they do that on the other crimes?
Because
we often say, well, the legislature knows how to tell us what to do because they did in this statute. And we could say, hey, they knew how to tell us what to do because they did it with burglary, and they didn't tell us with the rest of the crimes. I mean, that's one of the construction canons that we use, is if they do it in one place, then obviously they didn't intend to do it in another.
But I think it just more clearly shows, and you're right, but this clearly shows that this is an exception to what they thought the rule was. In fact, if you go back to Senate Bill 479 in 1992, they originally had aggravated robbery, and they phrased it, aggravated robbery committed on or after July 1st, 1993 is a severity level 3-person felony. When it then went into effect in 1993, they got rid of that. So I think by getting rid of that, they were thinking, we are saying that when it goes into effect in 1993, we've told you what the person felonies are. Those are what you're going to treat as person felonies convictions going forward.
And if this is so obvious, why did the state appear in front of this court in Williams and say to do something different?
Because we didn't know. We were short-sighted. We did not know that this would affect Murdoch, or that it would result in Murdoch, and that it would affect everything in the state and the way we've been doing our criminal history for over 20 years. We didn't know that. And I don't think this court would have reached that decision had they known that would be the result. They wouldn't have said, oh, this is the most fair and logical thing. Had they known that they were overturning the past, I don't know at the time Williams was decided, close to 20 years of criminal history, the way it's been done. I don't think the court would have made that decision, and I don't think the state would have asked for it. They were short-sighted. They didn't realize what they were asking for.
And just so we're clear, the short-sightedness is that the state comes here and always takes the position that will get a criminal defendant more time in prison rather than less time, as opposed to being consistent in statutory interpretation. That's the frustration here.
I appreciate the frustration, I do, but the state's urging you to make a bad rule does not overcome your duty to figure out what the legislative intent is and imply a legislative intent. I think relying on Williams is the wrong way to go. We need to figure out what the legislative intent is. If the legislative intent says Williams is wrong, then Williams is wrong. If you can say the legislative intent said, yep, all pre-1993 felonies were non-person, then I guess Williams was right.
Williams was decided in 2010.
Yes.
So if it was as wrong as you contend today, why has the legislature not changed the result in Williams or the statute in Williams to correct that error? It's been 5 years.
It has, but
Can we read anything into that?
that the legislator was as ignorant as the state on what the effect of Williams would be. The legislator is attempting to fix Murdoch now. They're doing, and are in the process of doing so. I don't think until Murdoch came down that we realized that Williams would have that impact. Everyone was unfortunately short-sighted.
And why isn't that the answer? I mean, frankly, I kind of harken back to earlier this week when you read about the Obamacare arguments, and I think the state of Kansas has joined the side that said, well, if there's a problem in the statute and the legislature can fix it. So why isn't the legislative fix the way to go with this, rather than having the court adopt different positions from what we were asked to do before and have decided?
Because you still have to find legislative intent. The rule of lenity, everything is subordinate to legislative intent. Williams didn't look at legislative intent. Murdoch didn't look at legislative intent. Nothing in Murdoch said the legislator intended that all pre-1993 convictions were going to be treated as non-person felonies. Nothing has said that. And unless you're willing to say that, I don't think this court can continue to say Murdoch and Williams were rightly decided.
What did
Counsel.
Williams have to do with pre-1993 crimes?
You're right, Williams does not. Williams is a post-1993 comparable, but it also didn't hold that was the legislator's intent. And maybe Williams is correctly decided for post-1993.
That was the only issue.
Right.
That was not the only issue, but that was a given in Williams because the crimes committed in Washington were in the mid, I think, 2005 and 6, correct?
Correct.
And so I come back to my point. If the legislature thought that Williams was so horribly wrong, why did they not try to fix it for the last 5 years?
I don't know that they thought it was so horribly wrong for post-1993 convictions. It's the pre-1993. And I think that's part of the reason the state was so short-sighted is they weren't thinking about what would happen to their pre-1993 convictions. And
Counsel,
Yes,
you keep saying legislative intent,
yes.
which is, of course, supposed to be the lodestar of statutory interpretation and construction. So can you just give me a quick summary of what you think your best argument is that your view of legislative intent is correct, as opposed to the view that would follow from Williams and Murdoch? You mentioned the burglary provision, which I think you also can see cuts both ways in terms of the application of the canons of interpretation and construction. What else do you have?
The plain language of the statute, the entire purpose of the act, I think.
Plain
is-
language and purpose are entirely
Right.
different things. So let's try and get straight.
I'll
What does
start
the
with
plain language tell us? Nothing, right?
It doesn't
That's your
give you a
position, it
specific
tells
rule.
us nothing? You're saying it's silent.
Yes.
Okay, so you say silence, then what do you have?
Well, I don't know that I say silence because it does have things like the burglary, but the purpose of the
I
act.
mentioned the burglary, what else?
The purpose of the
No,
act.
plain
is-
language.
oh,
I want
plain
to talk about
language.
plain language first. Do you
Okay.
have anything on plain language other than the
It
inclusion of the
keeps
burglary?
saying convictions.
Excuse me, I wasn't
I'm
done.
sorry.
Do you have anything in the act, in the plain language of the act, other than the burglary provision to say we're relying on a plain language interpretation?
The plain language of the statute repeatedly says convictions over and over. It doesn't say crimes. You've taken a rule that, or this court has used a rule that looks at the prior crime, but it says convictions. The PSI only looks at convictions. In every case that's been decided, no one's actually known the prior date of the crime. Murdoch, we didn't know what date the crime was committed on. Keel, we haven't known what date. Williams, I guess I don't know if they knew the date on that one. But the PSI, when they do it, they look at the prior conviction. They use the date of the conviction. They do not use the date of the crime.
Okay, and then you, in your additional arguments in favor of the legislative intent that you say today is the correct one. What else?
Is the purpose of the act in its entirety, was to standardize sentences, to equalize, the purpose of the act negates, I think, any reasonable interpretation that they said serious criminal history isn't going to be as serious anymore when they're trying to do comparable offenses.
What does that have to do with standardization? I mean, Murdoch gives us a standard rule. It's just a rule that the state doesn't like today. It liked it before. Now it doesn't like it anymore. But how does it affect standardization? I mean, there is a standard.
Because people convicted of rape pre-1993 get a lighter sentence than those convicted of post-1993, even though...
Okay, so I'm just going back to the reasoning. I'm trying to follow
sorry.
analysis as opposed to preference.
Right,
Because I think we have all acknowledged that the preferences have changed.
right.
So let's try to stick with analysis and not mere preference. So you say, well, it just doesn't make sense.
Right.
That's your argument. It just doesn't make sense. But that's not really analysis. That's preference. So let's go back. We talked about plain language. You gave me the two things that you think are plain language, the use of the word conviction rather than crime and the inclusion of the burglary provision. Then we're moving to purpose, and you're saying the overall purpose is standardization. How does the rule in Murdoch and Williams affect standardization negatively?
Because people committing crimes in the same year, so if you're committing a crime in 2007, their criminal history is not similar at all. It depends on when their crime was committed. If they had the 1992 rape, they get a lighter sentence. If they had a 1994 rape, they get a more harsh sentence.
Okay.
It would make, I
So
think,
standardization across that measure.
yes.
But there is a rule. You see what I'm getting at? This idea that somehow this is less predictable or less standardized is really not accurate. It's standardized, it's just a standard that the state doesn't like, right?
But it's a standardized that doesn't treat similarly situated offenders the same, which was the
Okay.
purpose of the KSDA. The similarly situated offenders, I think, are the current crime of conviction.
Okay. Anything else on that purpose of the statute?
Do not believe so.
Okay, and the other purposes you mentioned? Preservation of prison beds for violent criminals. Right, was one of
Right.
them?
And that is where the legislator has told us what they consider post-1993 to be serious offenses. And we should preserve prison for those.
Okay, that one's pretty easily to understand, pretty straightforward. You had a third purpose that you mentioned?
I have uniformity, public safety, which I think I've talked about as well.
Public safety is really pretty much hand in hand with the
Right.
prison beds for, okay, anything else on the purpose of the act that
I
you
think
want
I've
to
already
argue?
done standardized sentence and equal treatment for offenders, so I think I've covered everything on that.
Anything else on the construction what would we say, construction of the statute as opposed to interpretation? Any other factors, other statutory canons you want to argue, or legislative history, or substantive background considerations, such as a climate or a particular case the legislature was reacting to, anything like that that you want to add to your argument?
No, I don't think so. I think I've covered the climate was to standardize, I mean, the climate was the purpose of the
Kind of
act.
goes with purpose.
They haven't reacted
Okay.
at all until recently.
The reaction came when they got an outcome that was unacceptable.
Correct.
I think your first preference here would be that we disavow Williams and compare to the current offense. I guess that's the road that we would take if we follow your preference here. Is that right? I mean, the first preference would be Williams is wrong. Is that right?
Right.
And then we have maybe two different ways to approach this. If we don't do that, the Court of Appeals have stated maybe two different ways to do this, is for in-state convictions anyway. One would be to compare to the current offense, and we apply it that way. The other is to ignore the comparison and kind of go back to what the crime was at the time it was committed, say it was a robbery, and look at the elements to determine whether it was a person crime. I think that's the Wagner approach, we'll call it that.
Okay.
Do you have a preference of which way we would do that if we don't disavow Williams and we say in-state is different than out-of-state? How should we do that? Any preference? Because it's kind of two different pathways there.
I don't want to get trapped into a.
I'm not trying to trap you.
No,
I'm
no,
just
no.
trying to.
I'm just sorry. I'm just
Yeah.
don't want to ask for a bad rule again. I think the more logical to me is, do you look at society's norms today? You phrase it as
So
a
the comparable offense is what you
comparable
prefer.
offenses, yes. But if you say, well, the only time the legislator really figured out what person versus non-person was in 1993, and you look at the two, that's,
That would
I
work
think,
too.
acceptable as well.
Okay.
Those are just ways to distinguish Murdoch, basically.
Yes, by doing the fact that comparable offenses aren't present in the Murdoch. In this case.
I knew what you meant.
I'm sorry.
I knew what you meant.
Okay, thank you. I do know that multiple Court of Appeals opinions have said Murdoch is tethered to that 274711E, or I guess what's 6811E. I see I'm out of time unless you wanted me to address the paraphernalia briefly. You guys know? All right. Thank you.
Just so I'm clear, Williams dealt with out-of-state convictions post-1993, correct?
Correct.
And Murdoch dealt with out-of-state convictions pre-93.
Correct.
And Keel, today deals with in-state convictions pre-93.
Yes.
And you would like essentially for us just to erase Williams and Murdoch.
I don't know that you have to erase Williams and Murdoch's. If you want to say that they're distinguishable and that in-state rule has a different than out-of-state, that's acceptable as well. I have some trouble with it, but I do think that because there's a statute that refers to out-of-state, you can say that statute doesn't apply, so you don't have to do comparable offenses. You just look at convictions, and then we look at the legislative intent on what a conviction was and when we're supposed to determine what conviction to use.
Any guidance in helping us determine, once we've established legislative intent, whether we should go ahead and fix the problem that they
Well, I think
that they created or failed to appreciate?
I don't know that you're fixing the problem. I don't think you're legislating. I think you're saying that any other result is illogical with the purpose of the KSGA. So you're saying that based on the intent, the only way to read this act is to say that they're either person or non-person felonies pre-1993. And we either look at the time of the offense now, the current crime, or you go back in time, or you do a variety of other rules. I just think looking at the time currently is the easiest rule, rather than having to jump back through, say, 1992, 1993 statutes and figuring out what the crime was, the comparison, and all of that.
All right. Any more questions? Thank you, counsel.
Thank you.
I don't think I have anything new in response to Ms. Chalmers' argument here.
Any questions of counsel? Thank you. Thank you both for your arguments this morning. Court will take this matter under advisement.